Good afternoon from Bangkok, everyone, and welcome to today's webinar. We are thrilled to have you join us. My name is San Chaitirapan, and I'll be your speaker in today's event. Today, we'll be diving into the session entitled AI-related patent examination in Thailand, Trends, Challenges, and Insights. I hope you find today's presentation insightful and valuable to your line of business. Before we begin, there are just a few housekeeping notes to help the session to run smoothly. First, this webinar is being recorded. Second, all participants are currently on mute to minimize background noise. Third, we encourage you to engage with us by asking questions. Please send in your questions through the Q&A box or use the chat function located at the bottom of your screen. Fourth, all questions will be addressed at the end of the session. If we run out of time, we'll follow up via email. And finally, your feedback is incredibly important to us. At the end of the webinar, a QR code will appear on your screen. Please take a moment to scan it and share your thoughts. With that out of the way, let's get started. So I recently had a chance to speak with a senior patent examiner from the Thai Patent Office who, in the wake of rising artificial intelligence or AI-related patent applications, shared the developments of patent examination practice. First, some more important notes. This webinar is neither a legal update nor the Thai Patent Office's position on the subject. There will be no such update, at least in the next few months and possibly next year. This webinar is only meant to relate the insights, unwritten trends, if you will, from a Thai examiner regarding the examination of AI applications. I hope it will be helpful all the same. And here are the key topics today. For the said lack of legal update, the Thai Patent Office is now focusing on applying formality rules and patentability exclusion, as well as their underlying public policy in examining AI patent applications. It was also noted that the novelty on inventive step examination will remain pretty much the same as before, but we'll have some touch on some examples in this webinar too. The interviewed examiners observed some themes with the AI-related applications and shared their practical thoughts for these themes. We'll go through those themes one by one. And finally, we will end this webinar with a few selected topics which are not directly about patent examination, but they're somewhat related to AI and patenting, which I hope it will be interesting to you. Let us begin with the rules. These are Thailand's patenting rules according to the Thai Patent Acts pertinent to this webinar. Some of these align with those of the leading jurisdictions, while others are a little different. So I think it would be nice to cover them briefly here and lay some groundwork for our discussion. There are substantive requirements according to Section 5 of the Thai Patent Act. There are novelty, inventive step, and industrial application. You probably know how they work, so I'll move forward and we'll see how they apply to AI invention in the later slides. But these are the rules that I've said align with most of the leading jurisdictions. So I think we're fine with this. The next is formality requirements. The very pertinent one is the rule according to Section 17.3, sufficiency of disclosure. This is basically the same as other jurisdictions. Basically, A patent specification must teach the public how to work the invention in exchange for exclusive rights. And the final group of pertinent rules are patentability exclusion, especially according to Section 9.2 and Section 9.3. Section 9.2 exclude laws and theorems pertaining to sciences and mathematics from patent protection. And Section 9.3 bars computer program from receiving a patent protection. We will go on a bit more about Section 9.2 and 9.3 because they probably have some nuances which makes Thailand's local rules a bit different from other jurisdictions. So we'll go on more about these rules in more detail in the next few slides. Section 9.2, law and theorems pertaining to science and mathematics. It is important to note that Thai examiners often cite these bar against an abstract idea or mental activity as such, which often also borders on the lack of industrial applicability. But this exclusion does not bar a claim reciting a technical method or device whose function requires an application of law or theorem. These are by definition not abstract idea or mental activity or natural law as such, so they are clearly patentable. Overcoming this exclusion requires pointing out to the examiner which part of the claim recites either human intervention or application of laws or theorem as opposed to the theorem itself. The next one is Section 9.3, exclusion of computer program. In principle, this exclusion bars the protection of computer program as such. But while this arguably stretches the scope of computer program as such, the Thai Patent Office has an established practice to reject computer-readable medium claims based on this exclusion. On the other hand, this exclusion does not bar the patentability of computer-implemented method claims and computer device or system claims because they are considered not computer program as such. To overcome this bar, one may point out to the examiner that the claim recites the invention's physical features or real-world effects. Tangibility is often key to distinguishing the invention from a computer program as such. In part 2, considering the informal nature of my source, I believe it is more appropriate to frame discussions into themes that came up during my meeting with the examiner. The names of these themes are, of course, unofficial. We'll focus on each theme and the examiner's likely approach when such theme arises in a patent application related to AI. The first theme is defining the technical application or a finite group of technical applications. Thai examiners favor an AI-related invention that clearly defines the technical context to which it applies, because such an invention is very likely to be not the scientific or math theorem as such. In summary, a well-defined technical application is seen as helpful in the examination of AI invention against Section 9.2. For example, suppose a system or a method for detecting abnormal disintegration of a medical drug that is powered by a trained AI model. These should pass the Section 9.2 exclusion. Also, a well-defined and well-described technical application may establish the invention's technical effects. These should be helpful in the examination against Section 9.3 exclusion. On the other hand, a description of AI model or training method without its technical application is likely to be met with a Section 9.2 or 9.3 objection. But this is not an absolute dead end if the applicant provides basis for claim amendment and/or explanation of the technical application in the original specification as filed with the Thai Patent Office. The next theme is an application that is directed to a new use of AI, a technical application that the inventor believes that no one has ever implemented before. If that is true, then the examiner tends to accept the invention's novelty, provided that the claim limits the scope within that new technical context. However, consideration previously arising from other computer-implemented inventions, especially about automating manual process, applies well to AI-related invention. That is, the new use of AI requires a very detailed and convincing description of how, in view of the prior arts, such a technical application is not obvious and surprisingly advantageous. Failing this test, and the examiner would conclude that the claimed invention lacks inventive step. The senior examiner went on to comment about how some other applications claim that the novelty lies in the new training dataset or new training method for same machine learning model and same technical problem. In the examiner's view, these applications appear not inventive, and again, the specification must present a very detailed explanation about how the new dataset is not obvious and impacts the predictive or generative outcomes. On that note, I believe that the new dataset, the examiner was referring to the same set of predictive parameters, but acquired from a new data source. If, however, the new dataset means a new set of predictive parameters, then in that case, there should be a much better chance for an inventive step. The last theme that the examiner mentioned is the sufficiency of disclosure that is also tied to the public policy. The interviewed examiner emphasized that, in any case, a patent must serve the public interest, and that the applicant must satisfy their end of the bargain to obtain the exclusive rights. As such, a Thai examiner disfavors an AI patent application that does not disclose key enabling details, such as the nature of training dataset, choice of the AI model, or the AI training method. Naturally, an acceptable level of disclosure depends largely on the context. For example, if the training method is or is close to the invention's inventive concept, then that information is presumably not known in the relevant arts. In that case, it is advisable to disclose a lot about the training method. But if, say, the choice of AI model is quite a standard option for the job at hand, then perhaps a brief mentioning of a few preferred AI models should suffice. But a complete omission often puts the applicant at a great disadvantage. In this final part, we will cover the related topics which came up during the discussion with the examiner and which may be of your interest. The examiner noted that many AI-related applications are filed as petty patents, especially by Thai applicants. I also agree that Thai petty patent system is quite attractive for AI inventions. That is to say, apart from the 10-year maximum protection term, The rest of requirements look attractive. Inventive step is not required. Faster examination. The eligible subject matters are not restricted to tangible products, but extend to methods and remotely connected computer systems. The maximum number of claims is 10, which is quite generous comparing to other jurisdictions. And within those 10 claims, there can be any number of claim sets. All of these combined means it is possible to claim an AI invention as both method and computer systems as different claim sets, bundled in a single petty patent application. When asked if there is any DABUS-like application filed with the Thai Patent Office, the examiner was amused. For those who need some refresher, DABUS is an artificial intelligence model which was named as an inventor in a few patent applications filed in many countries about between 2018 to 2020. Most of the patent offices rejected the application because the machine cannot be an inventor. The Thai examiner confirmed that to date, there is no DABUS-like application filed with the Thai Patent Office. But according to the Thai Patents Act, the examiner gave their opinion that the application of that nature would likely be rejected in Thailand for reasons similar to other jurisdictions' patent offices in relation to DABUS applications. Moreover, the examiner also noted that there are some patent applications which they suspected to have been drafted by a generative AI. They commented that there is no legal basis to reject those applications based on the methods by which they were prepared. But they also advised that the applicant should review the application well before filing it and to watch out for consistency. Finally, the examiner revealed that the Thai Patent Office is considering updating its official patent examination manual to address the AI invention among other updates. The senior examiners are studying the practices of other leading jurisdictions, including USPTO and EPO, who informed this update. But the examiner also mentioned that the project does not have a set timeline for completion, citing the workload of the officers involved in the project. And that concludes my webinar today. Thank you very much for joining us today, and I hope my presentation was helpful. If there aren't any other questions after this webinar, please feel free to contact us. We'll be very happy to answer them.